All right, well, we've got a number of callers on hold, and we're going to take our first call for the evening. Welcome, caller. You're on the air?
Hello?
Yeah, you're on the air, sir.
I'm just calling because I want to know if, in order for me, so they could start taking child support before, so I have to go in front of a judge for that?
To pay child support, you mean?
Yes, yes.
Okay, you want to get child support established?
No, they're deducting child support. They're deducting child support already, but I never went in front of a judge for that.
Okay. Thank you very much for the call. I think what he's talking about is getting child support established administratively and what kinds of remedies he has for that, and we encounter that issue frequently.
Well, if you want to have child support established, we need to know if you've already been found to be the father. If you haven't, you could have a case to determine the paternity of the child, and then an amount of child support would be set. Nothing prohibits you from making voluntary payments before that time, and if you really believe you're the father, that'd be a very responsible thing to do. But in order to establish child support judicially or through an administrative proceeding, you would have to go and file papers with the court or the administrative body and have them set forth the correct amount of child support.
Very good. Because child support, as you just alluded to, can be established one of two different ways. It can be done through the courts, or it can be done administratively. Because most people are familiar with what they've seen on TV or in the movies, that if something is going to be established legally, that you go for a judge with the black robe and all that. It's a new I guess, experience for somebody when they go to the Illinois Department of Health Care and Family Services. And it's important for people going through that process to understand is that you do have the right to judicial review of anything done with the Illinois Department of Health Care and Family Services.
That's correct. Oftentimes the Illinois Department of Health Care and Family Services will enter an order. It might not be the correct way to do it. They don't have the time to do it as carefully as they should sometimes. And when that happens, you have the right to go and take it to a judge. That's very important that safeguard exists.
Yes, absolutely. And we still have a number of callers. Next caller, you're on the air.
Hello.
Welcome.
How you doing?
I'm fine. What's your name?
My name is Aisha Thomas.
Good evening. What can we do for you?
Yes, I have a question. About 8 months ago, my ex-wife, she just dropped off our kids and left. Now she wants custody of them back. DCFS was involved, and they found out there was a sign of mental abuse. I just want to know what are her chances of her getting them back.
Want to take this?
Yes. Was the mental abuse found against the mother?
Yes, sir.
Okay, well, I think that's very relevant, and I think that you really need to fight this, because if you don't have a court order, it's going to be very difficult to maintain the peace. There's going to be a big struggle over the children. Have you ever been to court on this case?
No, I haven't.
Well, you said it was your ex-wife, correct?
Yes.
So they were divorced how long ago?
I want to say maybe about 11 months ago.
11 months ago.
Yes.
Okay. So what was the court's order under the judgment for dissolution?
They really didn't give anybody. Well, at one point they gave her custody, but I guess she was just fed up with taking care of the kids. So just one weekend she dropped them off and never came back and got them. I haven't heard from her since until a couple of weeks ago when I got the letter for custody.
All right. So it sounds like there may be other issues there as well.
Certainly. I think that you really need to get into court very soon so that you could get an order so that she doesn't come around and try to take the kids away from you. That would be very detrimental to them, to have a big struggle. The police would probably be called. They might make the wrong decision. They're not really equipped to decide those issues. And they might take control of things. Mm-hmm. You really want to keep your children out of that sort of an environment. So go ahead. I'd recommend that you contact an attorney immediately and start something going so that you can avoid those sorts of unpleasant experiences.
My experience has been that judges liked continuity, consistency,
Definitely.
stable environments for children, and children moving back and forth repetitively between conflicting parents can't be good for children, I would imagine.
No,
You've got a lot more experience
yeah,
than that.
It would be very detrimental to the children, and that has to be established in court very quickly.
Very good. Next caller, you're on there.
Hello, yeah, I just had a question. I've been paying child support for 2.5 months already, but my ex-wife doesn't want to let me see the kids, so I don't know if how can I do?
So you're paying child support pursuant to a court order, correct?
Yes.
All right. Were you in court?
Yes.
Did were you able to get visitation rights at that court date?
Well, they didn't tell me nothing about that. They just told me that they were going to deduct the money out of my paychecks.
Right.
Yeah.
I think that's...
But they haven't gave me no letters or nothing for that?
Right. If nothing is said about visitation rights, I don't think anything was going to be put in to the court order about that. It's just my opinion. I don't think it's necessarily fair that we have all the resources of the state to establish child support obligations, but nothing affirmatively to be done about establishing visitation rights.
That's true. There are no public agencies that devote themselves to enforcing visitation rights or establishing them. This is another case in which you should probably be in court immediately. You're entitled to visitation, but your rights only will be established through a court. Otherwise, if you just leave it up to the mother, you know what's going to happen, nothing. So you really have to be in court. You should be entitled to liberal visitation. It should be a specific schedule.
Absolutely. I mean, interference with somebody's visitation rights is a crime under Illinois law. It's a criminal offense. But those visitation rights have to be spelled out in a court order. If you call 312-795-9060 and request a copy of it, somebody can send you a copy of Illinois' visitation interference statute. I actually know a number of gentlemen who I've represented in the past that had gotten into trouble with the law because they had these verbal agreements. Yeah, he can come see the child every other weekend, things like this. But there's nothing ever put in a court order. And he'll go over there on what he thinks is his night. He'll be told, go home. There's nothing, you're not going to see the kids this weekend. And then he gets upset, and of course the police are called. And he's got no legal right to be there. And he's looking at getting in trouble with the law, and he's treated like a criminal for, just wanting to see his children. So it's definitely a situation where if he had had a court order saying he has alternate weekends or the first and the third weekend, he can be the one enforcing his rights as opposed to being in court with his liberty at risk.
It's also good for the children to know when they can see their father.